Welcome to another episode of Ferrofan Focus. In this series, we're speaking with some of music's brightest pioneers and power players from all corners of the industry, bringing you the best advice and insights. Before we get started, I just want to give a quick shout out to Ferrofan. Ferrofan is a CRM built specifically for artists and the teams that support them. So make sure you head over to ferrofanmusic.com to learn more about how we're helping artists grow, understand and nurture their fan base, and how we can do the same for you. I recently spoke with music business lawyer Ryan Schmidt to get the latest outlook on statutory royalty rates and what it means for artists, as well as delving into the infamous Blurred Lines lawsuit and the ripple effects that case had on music copyright law. So let's focus up and dive straight into the conversation. Royalty rates, there's been a lot of fluctuation on that. I know there was a big, maybe it was 2018 they decided they were going to increase it, but then it got kicked back. Push back with Spotify, fought against it. Where are we at with that now?
So that is, when we're talking about statutory royalty rates, we're talking about mechanical publishing royalties. There are no royalty rates for streaming the master sound recording. There's no set royalty rates for the public performance royalty. That's something that's negotiated on a blanket license basis to ASCAP, BMI, PRS, that sort of thing. But we're talking about the mechanical royalty, the right to reproduce. And since streaming, you're technically creating like a cookie or temporary file, you're making a reproduction or a digital download. So that all requires a statutory set rate. For the longest time, it was 9.1 cents. For 20 plus years, it was 9.1 cents. And it gets up for review every few years in front of a copyright royalty board who hears evidence from both sides, both the music publishers and songwriters, and usually that's backed by some big organizations like the National NMPA, and then on the DSP side, Spotify, Google, etc. One tries to say we need higher rates. The other one says we need to keep it the same or lower it. Where we're currently at is that rate was increased from 9.1 cents to 12.3 cents, I believe. And then there's also a fraction based on subscription, ad revenue, and that sort of thing. But it didn't go into effect right away because Spotify appealed that decision. And that was held up in litigation for about 5 years. It did not get completely resolved until this past year. So there's all of this royalties that were collected that were just held in limbo, and they were paying out at that old rate. And then a judge finally decided we're going to reject that appeal, and you're going to have to pay at the new rate retroactively. So there was a bunch of about 5 years of royalties out of the higher tier that finally got paid out, and there's some issues and questions that I even see about whether that all got paid out properly and timely. But yeah, now we're at a staggered system where up until 2027, I believe, we will see incremental changes. And then that's when we have to renegotiate the next round of mechanical royalties.
Got you. And am I right in thinking that Spotify tried to skirt around this by presenting themselves in other ways, like with the podcasts and bundles and things like that?
You're absolutely right, and they're currently being sued by the MLC for that very very reason. The royalty rate is a percentage of. You have two options. You can either do the flat royalty rate, which is that 12.1 cents, and this is really for compulsory mechanicals. If somebody were to buy a permanent download or print a CD, we're going to use that rate as long as it's under 5 minutes, and then if it's after 5 minutes, that's some fraction additional. But if it's streaming, ads, or subscription, it is some fraction of that DSP's net revenue. And what Spotify has decided to do is they're no longer a music platform. They're a music, audiobook, and podcast platform, which in their argument, since they're split in thirds, they're the part of their platform subject to these royalty rates should now be 1/3 of that revenue, which isn't a if I was their lawyer, isn't a bad argument to make because it will cost them less money, but it's something that's received significant blowback from the music industry, and I think they'll ultimately lose that argument.
Another thing I wanted to touch on that I'm very excited to dive into is looking at ripple effects of major cases. I know you've previously said in interviews I've seen that you feel like the Blurred Lines case with Robin Thicke and Pharrell Williams against the Marvin Gaye estate really did change the course of history for how those were viewed, given the verdict. For the viewers, just give us a little bit of background on what happened there.
That case involved the estate of Marvin Gaye and Robin Thicke, Pharrell, their record labels, where the estate said that Blurred Lines infringed on the vibe or feel of Marvin Gaye's Got to Give It Up. Essentially the drum feel and that syncopated rhythm. And prior to that case, only protectable elements of a song could be subject to copyright infringement: lyrics, melody, and harmony. And really, we were talking about substantial similarity. The more similar, the better. Verbatim copying is a great starting point, and then you got to back it up, and it's a sliding scale. This had none of that. This had some drum sounds that were similar, and a kind of an overall feel and vibe. It wasn't helped by the fact that Robin Thicke and Pharrell admitted that they were inspired by Marvin Gaye's song, and then they later at trial try to backpedal that, and they kind of looked like they were being untruthful. And I don't think that generally helps with a jury. I think the better approach would have been, we're absolutely inspired by that, and that's how every single songwriter that's ever lived has been inspired by what's previously existed. That doesn't mean it's infringement. If they had stuck to something like that, I think they would have potentially kept their credibility with the jury. But the case ultimately went in the way of Marvin Gaye's estate. And it has, as far as what precedence means and where it goes, that was a win in the trial court. So at that level, that only applied and affected the parties of that case, nobody else. Then it gets appealed to higher courts. And it ultimately gets appealed to the Ninth Circuit Court of Appeals, which is the highest appeals court in California. It's the federal circuit there. And that appeals court upholds the trial court's decision, which means that every court sitting within the Ninth Federal Circuit, including the federal trial courts, now all have to follow the Ninth Circuit Court of Appeals decision. So it's binding everywhere in the Ninth Circuit. Other courts haven't adopted it per se. Some take the approach that it's good, persuasive authority, and in other courts, including the Second Circuit, just say it's a bridge too far. We really need to stay closer to this substantial similarity and verbatim copying. And that's exactly what we saw actually with the Marvin Gaye's estate's lawsuit against Ed Sheeran, which was in New York. They try to file kind of under the same team and same arguments that Ed Sheeran's Thinking Out Loud copied Let's Get It On, and they lost that case because the Second Circuit said we're not bound to the Ninth Circuit's decision, and we think they got it wrong. And essentially, these are building blocks of a song, and they don't include any verbatim copying of lyrics, melody, harmony. But the impact of that case beyond just where it's binding in the Ninth Circuit is that people are a lot more litigious on copyright issues, especially if they're really gray, if they're outside of the zone of a really good, solid copyright case, even if they sound like they were inspired by or just similar to, people are a lot more likely to try to litigate that. What's happened is you have a new influx of these cases all around the country because why not? That's kind of the culture these days. You have a lot more checks and balances before a song goes out, where it might run through a major label's in-house musicologist to give a stamp of approval that they think that there's a low risk of copyright liability there. And, ultimately, I think the music creator and the music fan suffer because there's the way that things have been done and what is technically legal has now been questioned a little bit, where people are now more likely to just give artists and songwriters credit for something they didn't work on. One example is Sam Smith's "Stay With Me." Tom Petty is listed as a songwriter on that song because of "Don't Back Down." And it wasn't even something, I don't know the full story of it because it was probably all handled behind closed doors, but it wasn't something where I think Tom Petty would have won a copyright lawsuit. And I don't know who reached out to who, but it could have been a situation where Sam Smith's team just felt it was safer and that sounded similar enough that'd be safer just to offer some publishing points and avoid the whole mess of the Blurred Lines case.
Good. I guess back when that song came out, it was pretty fresh out at the time. So maybe 10 years on, maybe it wouldn't be the same, but maybe it would. It sounds like they're taking it all very seriously now, and that's the big consequence.
Absolutely. So you gotta keep that in mind. And even, the amount of calls I get on a daily basis about potential infringement have gone up since that case. And most of the time they're not great cases, but I think it's created a culture where people think, let's spin the roulette wheel and see if we can't cash out on a case like this.
Yeah, absolutely. So that's obviously the downsides of it. To play devil's advocate, obviously it then does lead to Marvin Gaye's estate, suing Ed Sheeran as you said, but then he's unable to win that case and prove that inspiration and songs have to sound the same. I have to use certain chord structures and things like that. So you could argue that without the Blurred Lines case, you don't necessarily get that, and that could have been very important in the future for artists to use.
Yeah, and I think the practical effect of it is that most artists, songwriters, producers reasonably don't understand the limitations of that decision and where it is binding. They just know that, well, Marvin Gaye's estate was able to do that, so I should be able to do that as well. So even whether it's binding or not, I think there's a general belief that if anybody uses something that I think subjectively sounds like my song, I should be able to go after them for money damages.
Got you, yeah. And where do you stand on smaller artists taking risks by putting out, using samples without getting them cleared? Is that something they should just ask for forgiveness rather than permission?
From a legal standpoint, I'm always going to say try to get those cleared. And there's so many different avenues to get pre-cleared samples. So there's not really an excuse. If you use something that's big and popular, even if you're not making any money off of your song, you're using that sample for a reason because it's big and popular and iconic and it sounds great and it's providing value to you and your song. So you need to, get those permissions and get those cleared. It has worked in the past for some artists who have gone the infringement route and maybe they lost big on one song, but it kicked off their career. Juice WRLD is a perfect example of an artist who stole a Sting sample and lost out on that song, but it propelled his career. that's really, really risky, and it's a rare situation. It'd be a lot better to either get those permissions, assuming you can get those cleared. It's a reasonable rate to get those cleared, or find something else. Find something that has, those samples that are pre-cleared, whether that's, like a sample library or, a subscription or something like that, or work with a producer or a loop maker that, work directly where they can give you those rights, or something that's in the public domain or Creative Commons that you don't run into those same type of legal issues. Because it's too risky to just release it without any protections and just hope nothing happens. Because the best case scenario is that nothing happens with the song, nobody listens to it, and you never have to get a scary letter from a lawyer. But the worst case scenario is that your song takes off and is making a killing, and now Sony Publishing or Warner Chappell or somebody's coming after you to collect. And if it's doing really, really well, they're not going to want to kill the song. They're just going to want to take the lion's share of it as a way for you to repent for stealing their song.
It's not just the financial side; it's also the time it's going to take. Then you've got to go through the whole legal battle as well. It doesn't seem worth it. I know this is separate to sampling, but there was the case with Katy Perry, the Dark Horse song with, I think the artist was Marcus Gray, something like that. Obviously, I know he originally won his battle against her, saying that she, taken some notes from it. But then obviously, 8 years later, it got overturned and he never received that money. But like that can, financially cripple you, and the time it takes, it just seems crazy to even go through with it.
Well, that's the other thing. If the more money you seek, the more incentive you're giving the other side to fight this thing to the death. And just because you win a case, and it could be a dollar or it could be $10 million. You get a piece of paper from a judge and you have an order and you have the right to collect that money from the other side. But that doesn't mean that the very next day, Katy Perry says, that was completely my bad. Who do I make the check out to? Now you have to go through legal steps to actually collect that, wage, garnish, and try to do all these other things to find that money, assuming they have it. And if it's a big enough amount, they're going to appeal it, which is going to put all that collection on pause anyway, and you could ultimately lose. So it's a lot of money, litigation, zero guarantee of ever getting a payday. Always going to be in everybody's best interest to work something out cooperatively on the front end without all that time and money, even if it isn't a perfect resolution. What I say to clients when they're settling something is, you've done right by everybody when everybody is a little unhappy about that final result, because you have to give and take a little bit to get that thing resolved, because otherwise everybody's spending so much money and no one really wins.
Yeah, that makes sense. And would you say it's harder now for the smaller artists to go up against the giants than it ever has been, or is it easier since you've had some other case law?
It's harder. It's harder because depending on where you're at, the case has to be really, really good. If it's something where somebody is stealing your actual lyrics or your actual sound recording, you can hire a lawyer, you go right to the label, and they will try to work that out with you without having to file a lawsuit. That's good. But if you're relying on the blurred lines type argument that it takes a feel, they're going to say, yeah, good luck trying to convince a judge of that. We'll see you in court. And, that's really a coin flip at that point. And you have to convince a judge and a jury that that's similar enough. But you've already spent how many years and, hundreds of thousands of dollars in legal fees. And is that really worth it?
Yeah, definitely. And just thinking of the vibe again. So do you think, had they actually just pleaded that he did inspire them, they would have won? It was that, and that was their only reason, really.
I don't think that was the whole turning point, but I don't think it helped. I think it was just it was a wacky case where this group of jurors and this judge was convinced that under these circumstances, this could be copyright infringement. But I think anytime you give the jury reason to not trust you, you've lost, because it's such a psychological game that they need to like you as a person, and they need to like your attorneys and how you talk and present. And if you do anything that kind of alienates them or loses trust with them, then it's hard to get that back, even if you might be on the right side of the legal case, because people go off of gut feeling, even though they have some laws that they're going to have to base their decision on.
Yeah, absolutely. And that decision changed everything, as you say. Are there any other like ramifications that stand out for you from that case?
No, I think we did touch on most of those. Yeah, I just think it hurts. It ultimately hurts the songwriting process, and it makes people a lot more cautious about taking inspiration, which is really the building blocks of songwriting.
Yeah, yeah, and other. So, would you say it's as bad now still as it was when that case was fresher?
Oh yeah, yeah. It's just as bad, if not worse.
Just always top of mind now. Yeah, yeah. Got it, got it. So we spoke on a few things as well about key practices you can do as an artist. Whatever tips do you have for artists to protect themselves?
Always have agreements with your collaborators. That's probably the most important and the starting point for anything in your music career. If you don't have an agreement of how your publishing and how your masters are going to be split from both a revenue and royalty standpoint and an ownership standpoint, you are really leaving too much at risk. You never want to have paid a session guitarist a couple $100 to play on your song just for them later to say, oh, by the way, I own 50% of the publishing on that. And that's something that you can run into an issue with if you don't have clear agreements, because what the Copyright Act says is that anytime two or more people create a work together and they intend to create a final project collaboratively, they can be considered joint equal authors of it. That's the default rule. It's kind of like dying without a will. If you don't tell the government where you want all your stuff to go when you die, they'll just decide for you. And there's no right or wrong answer for how music is split. If a singer-songwriter wants to own all their copyrights and they want to pay all their folks in exchange for owning those copyrights, that's completely fine. That just needs to be backed up in a signed agreement with all the parties.
And if it's not signed, written communication is obviously important. If you've got like text messages that are agreeing things, is that also viable if worse comes to worse?
Yeah, there's no legal requirement that things be in a final signed wet ink signature DocuSign version. It's really, is there enough to show that the parties mutually agreed to these terms? And that can be in text and that can be in email. And as long as there's hey, I really enjoyed working on this song today. Do you agree that for song A, you and I are going to split the publishing 50-50 and I will own the master sound recording copyright 100%. Does that work for you? Yes. If you have that, now it's a very, very simple agreement that doesn't cover everything under the sun that, maybe a formal contract would cover. But as far as just those issues, as far as ownership, that is good and that is binding.
Gotcha. And I think it's always a good place to start from, because obviously it can be a bit daunting and having to try and sort all that out. So having a habit of at least getting that as a first step is good. Obviously, just make sure you're happy with what you're saying, because you can't really go back on that if they agree.
And do it in email, because email is a lot harder to lose and misplace. People do change phone numbers, they do delete old text messages, things get lost. But if you do it in an email that's now time stamped, you've got their email address, it's going to hold up a lot longer. Also, in a text message, I could change whoever's contact name and just create a new contact, and I could have my friend who isn't Dave Smith have a conversation with me, and it looks like that. It could be manipulated a lot more. So I generally like emails better. But if Instagram direct message or text is all you have, that's going to be better than nothing.
Probably just best to screenshot it so that no one deletes anything. Yeah,
absolutely.
Okay, perfect. That's great advice for everyone, I think, there. Thank you so much for your time, Ryan. Where can people follow you?
The best place to find me is on Instagram. It's at ryanschmidt.esq. And there I provide daily tips and tricks on how to navigate the music business. I have a series called Ask a Music Lawyer Anything, where folks can reach out and ask some questions and get a response from an attorney. And that's where you can find me.
Marketing music as an artist isn't just about getting attention, it's about keeping it. Anyone can get lucky enough to go viral, but ForeverFan gives you the tools to build real, lasting connections. Instantly get access to a mini site that allows you to spotlight your unique brand to stand out from the rest. Use direct-to-fan management tools that allow you to understand who your fans are and where they are, so you can send curated texts and emails. And then create automated engagement campaigns that keep every fan feeling special, because ForeverFan continues to work for you 24/7, so you can make a good impression on current and future fans at all times. Your music deserves to be heard, and your fans deserve to feel connected from their first listen to forever.